next case for the morning is Joyce Morgan versus Consun Food Industries Incorporated. As you're getting settled, I'm sure you know that you have 15 minutes to present your argument. Appellant, you may reserve up to 5 minutes for rebuttal. And how long would you like to reserve?
5 minutes, please.
Listen, I will keep track of that time. I'll try to let you know when you get to about a minute left in your time.
Thank you.
May I ask a procedural question? Because we have two appeals that are consolidated, will we be arguing the appeal and cross appeal together in our 15-minute time period?
Thank you for asking. Yes, that will be the expectation. You'll argue both here at that time, not have any rebuttal time for you, and address all that when you come up to speak. And you can divide up your time however you choose to on the two arguments as you do that. The argument can be recorded. If you each come to the podium, when you are at the podium, please make sure you introduce yourself. Make sure you stay behind the podium so we can record you well, and make sure you speak in a clear voice so we can hear you and therefore you can pick you up. If you do have any names of children, minors, or any victims, if you would please use initials for them rather than their full name, although don't know we have anything in this case really apply in this matter. We read your briefs and are ready to proceed when you are.
Good morning, afternoon now. May it please the court. My name is Frank Consolo, and I have the privilege of representing the appellant, Consun Food Industries, Inc. In this case. It's almost deja vu. We were here almost a year ago to the day, February 23rd, and Mark and I argued this. So I just want to point out, for purposes of my oral argument, two issues for me, and certainly ask you ask me whatever questions you have. So first, I just want to direct the court's attention to the first and fourth assignments of error, and those deal with the failure of the trial court to direct a verdict or grant a judgment notwithstanding the verdict on the cause of action for the negligent retention and supervision. As we submitted to the trial court, it is the statute of limitations for such a claim is 2 years. The plaintiff had alleged that she was constructively discharged May 27, 2012. Her fatal date would have been then May 27, 2014 to bring her claim. This case before you wasn't filed until April of 2018. The initial case was filed December 26 of 2014. That's 7 months after the May 27 fatal date. So we believe that the court erred there in not directing the verdict on the statute of limitations issue there. Now I know my opponent has raised issues concerning Ohio's new anti-discrimination laws under Chapter 4112, but those don't come into effect until April of 2021. We've had numerous cases since then, and it's in my briefs to you, that it's not to be applied retroactively. And I also point out that the plaintiff appellee is also arguing under RC 4112.14, she gets to have the statute of limitations told, but that deals with age discrimination. This isn't an age discrimination case. As I said, the amendments cannot be applied retroactively. And I also put in there for you, there is law that says that a separate independent action is not told by just the mere filing of the EEOC charge. So just based on that, we request that the directed verdict and or JNOV be granted to my client, and that the general verdict, punitive damage and award of attorney fees and costs be vacated. And then the second cause or assignment of error I want to draw your attention to is the second and fourth, and that deals with the gender discrimination claim. And as we pointed out in our papers here, assuming the plaintiff met the first three elements of a prima facie case, it's our position that she did not meet the fourth element of the prima facie case. So that fourth element is whether she was a comparable non-protected person received better treatment than she did, right? So in the pleadings and in summary judgment in this case, the plaintiff saw fit to compare herself to the alleged harasser, which was her male co-worker, Todd Wallace. However, to meet the legal standard, she would have to show more than what she alleged. She says Todd was similarly situated because they had the same supervisors, had similar hours, and similar job duties. But the true test is she would have had to prove at trial that Todd or a other male had complained about harassment, that Todd or that other male had reported the complaint to the supervisor, that that supervisor, here was Mr. Churchak, investigated it, but investigated it more favorably towards the male employees who were complaining as compared to her as the female employee. That's what the law says our standard is, to compare it. So we believe she failed to produce evidence that she was treated differently in the investigation of her harassment complaint for those reasons. And again, this is a general verdict, so we would ask on that issue that the directed verdict and or JNOV be granted, the general verdict be vacated, along with the punitive damages and award of attorney fees. And absent any questions from the panel, that's all I wanted to use my oral argument for today.
Thank you. You'll have your 5 minutes for rebuttal when the time comes.
Thank you.
Good afternoon, Your Honors. My name is Mark Owens. I represent the appellee and cross-appellant Joyce Morgan. Consun attempts through this court to nullify a verdict by a jury of Ms. Morgan's peers in a very lengthy and thorough trial in this very building that went on for 9 days and which was supported by a preponderance of the evidence as to each and every claim. The jury verdict should be upheld in this case. Consun's appeal should be dismissed and denied. Consun's arguments in this briefing go largely to the weight of the evidence. I know that's not what was argued here today. Legal issues were argued, but much of the briefing that Consun presented to the court is based on the weight of the evidence and Consun's own evaluation of the credibility of the witnesses at trial, which of course would not be appropriate for JNOV or motion for directed verdict, which must be based on the sufficiency of the evidence. The evidence here was overwhelming in favor of Ms. Morgan as to each and every claim. Now, with respect to the first and fourth assignments of error that Mr. Consolo argued, 41-12-14E2 does allow the tolling of the statute of limitations for the period in which the claim is in the administrative body, the EEOC or OCRC, while the charge is pending. The negligent retention and supervision claim was part of the overall bundle of claims that were submitted. It was part of the gender discrimination that was all submitted to the EEOC or OCRC, and so it would not have made sense to separately file a suit just on negligent retention and supervision while she was waiting for a right to sue letter from the administrative body. They are all two separate claims, but they were presented together as one bundle to the administrative agency. It was tied up in the administrative body for 2 years, so that time period should not count. It should be tolled for statute of limitations purposes. I believe Mr. Consolo referenced the 2-year statute of limitations. I do not believe that's right. I mean, it was a negligence claim. It would be at least 4 years at that period of time when that claim arose. And it was timely for all the reasons that we've argued in our brief. It was refiled within the statute of limitations period and certainly within the time permitted by the savings statute. So Judge Moraldi did not err in allowing that claim to go to the jury. And as you know, there's an exception to the presumption against retroactivity when the statute can be classified as remedial or procedural. That's what this statute is. It's not a substantive statute, it's remedial, it's procedural, and so retroactive application is appropriate here, even though the statute did not come into being until I believe it was April of 2021, retroactivity is proper, and we provided a lot of case law to support that when it is a procedural measure. The second and fourth assignments of error, gender discrimination. If we think about Mr. Consolo's argument, it just that would quelch and suppress any ability for women in workplaces to assert a gender discrimination claim if they had to have a situation where they had to find a male employee in the same small workplace that had also complained of gender discrimination. That just doesn't happen, as you know. She did show that a comparable non-protected person was treated more favorably, which was Todd Wise. Todd Wise, the evidence was overwhelming. What was presented to the jury, that how he, the things he would say, the vulgar things he would say that were sexist in nature, only to women employees, and especially to Ms. Morgan. The fact that he was never disciplined, and the fact that he wasn't written up, basically no consequences for him whatsoever. They had the same supervisor, Mr. Turchak. He was the drug supervisor for both Ms. Morgan and Todd Wise. Mr. Turchak, as the evidence was presented to the jury, failed to investigate, failed to interview any employee, failed to implement prompt and immediate corrective action to stop any further harassment by Mr. Wise, who was similarly situated and treated more favorably. Court provided, jointly submitted, and jointly agreed to jury instructions. The jury followed those and found, based on the preponderance of the evidence, that there was gender discrimination here in favor of Ms. Morgan. The third and fourth assignments of error, of course, hostile work environment. The briefing contains the same legally inaccurate and sexist argument by Consun to the court, as it argued below, that somehow Ms. Morgan had to be propositioned or touched or asked to perform some type of sexual act before it could be hostile work environment, which is absolutely untrue. The actual evidence at trial showed that the harassment was not welcome, was never solicited or invited. Her conduct of avoiding Mr. Wise, complaining to her direct supervisor, Mr. Turchak, contacting HR at the corporate office to complain, even having to call the police to intervene, established that the harassing and unlawfully discriminatory behavior of Mr. Wise was unwanted, unwelcome, and it was highly offensive. So there was ample evidence here of anti-female animus. And as you will see in the record, I won't even repeat the things that were said by Mr. Wise, but they were very anti-female and very offensive. As Mr. Consun did not argue these other causes of action, I won't spend a lot of time on them. I think our brief is very thorough as to those arguments. I will mention, however, that the jury heard from our expert, Mr. Timothy Dimoff, a very esteemed expert in the area of not only security but also employment matters and investigatory procedures. They argue in their brief that he should have been excluded because his testimony went to the issue of law, and we cite ample authority to say that experts may opine or infer on an issue that embraces an ultimate issue to be decided on by the trier fact, and it does not usurp the function of the jury. And that's, of course, Evidence Rule 704. What he testified to was what a company would or should do in the face of workplace harassment. He testified as to whether specific actions may have caused the hostile work environment, and he testified as to whether a company has a duty to train its management on sexual harassment, and then he evaluated the facts that were presented to him to say that no, there was no adequate investigation here. No, they did not follow the standards in the industry. And that testimony was valid, and it was able to be relied upon and was relied upon by the jury in this case in rendering its verdict. As for our cross appeal.
Counsel, before you go to your cross appeal, hypothetically speaking, if this court were to decide that the negligent supervision claim we ran afoul of the statute of limitations, what are your thoughts about the rest of this?
Well,
Small question.
I mean, the the other claims certainly would be valid, even if that one were knocked out, and the jury's verdict would still be there. The compensatory damages were not just for that claim, that they were for the gender discrimination. Punitive damages were not based on the negligence provision. So I don't think it would change anything other than just having one less cause of action that the jury rendered its verdict on. So I don't think that would cause the verdict to be thrown out and having to have a whole nother trial because of one claim. Now, relative to our cross appeal, the biggest issue I'd like to bring up is the fact that Judge Moraldi reduced the damages awarded based on the 45% contingent fee agreement. Now, the Supreme Court has been very clear, and we've cited the cases to say that a trial court's rendering of a decision on attorney fees based on a contingent fee agreement when you have a prevailing party is an abuse of discretion. Contingent fee is one of the factors that's already included in the lodestar. And in this case,
so if the judge did use that as a consideration, because
right.
it looks like he went through a large analysis of that, the lodestar factors, and came to the conclusion that he's going to award that amount, the contingency fee amount, how is that an abuse of discretion?
Well, because, I mean, that shouldn't even have been, he seemed to have weighted that very heavily. He felt that the contingent fee of 45% was appropriate, and part of his analysis was also the fact that the case had been pending for so long, and this is where he makes another error. He abused his discretion in basically prejudicing us because there was a dismissal without prejudice. And, you know, the judge says, well, had it not been dismissed once, a lot of time could have been saved. We never would have gotten into the whole COVID situation, and this case would have been over years ago. Well, that may be true, but Ms. Morgan had an absolute right to one dismissal without prejudice, which she exercised for valid reasons. The case was refiled timely. There was additional discovery, and we didn't redo all the discovery. There was some additional discovery that was done to support her claims. And so you can't prejudice Ms. Morgan because she exercised the dismissal without prejudice. I mean, he made a big point of that in his opinion, and that clearly was an abuse of discretion to do so. He also,
You're saying the trial court can't even consider that as a factor with the lodestar, that there was a dismissal and that caused the case to go further.
that's not one of the lodestar factors, Your Honor. So no, I don't believe that that is an appropriate consideration. To consider that at all is to do what the Supreme Court has ruled is absolutely an abuse. You cannot use a dismissal without prejudice in a way that harms or prejudices the party who exercised that right.
And I don't know, can the court consider the length of time of the case and any delaying factors in the lodestar?
I believe it can consider the length of time in the case and causes of delay, as long as it's not because there was a voluntary dismissal. And certainly he did not mention anything that was done by the plaintiff or by plaintiff's counsel that would have caused this case to drag out, other than he only mentioned two things, the voluntary dismissal, and then he mentioned COVID, which he acknowledges, you know, none of us could have done anything about COVID. The court was closed for an extended period of time. So yes, the case was several years longer than it had to be due to COVID, and other than that, we just have the voluntary dismissal, which can't be considered. One of the things we asked for, one of our other arguments,
Which can't be considered or shouldn't be considered. Is there some case law that says that that the court can't consider voluntary dismissal when it's doing a lodestar analysis?
well, not other than the fact that, well, it's not explicitly part of the lodestar, not one of the factors, and I would say it's not proper and it can't be considered because of the admonition that it cannot prejudice a party. By applying it in that way, it does prejudice a party. It's reducing the amount awarded for attorney fees based on the fact that an attorney files a voluntary dismissal without prejudice with consultation with the client, which is an absolute right to do. course, we know from the case law side of it, you can't increase an award based on a contingent fee. So I would argue it should go both ways. If you can't increase the award because of a contingent fee, you shouldn't be able to reduce it either because of a contingent fee. The lodestar is based on the number of hours worked and what the fees were based on the legal work that was reasonable and had to be done. And of course, a factor in support of that is the fact that it was a very favorable outcome. She did prevail. She did go through trial, counsel went through trial and all the preparation, and deserves.
Hang on, 1 minute left, counsel.
Okay. And deserves the full compensation. So I will reserve that 1 minute for rebuttal, which
Well, all your time is now, so if you have anything else to say about
Great.
your argument, please proceed.
Okay. Let me just look and see if there's anything else that I wanted to mention. Prejudgment interest we have not touched on. Of course, that's briefed heavily in our briefing, but there was no good faith settlement attempt here, and we showed the numbers and the time it took to even get up to $15,000, much less to, I believe, the highest amount offered was in the middle of trial, $25,000. So, and we see from the jury's verdict, our original demand was $250,000. The jury's verdict it wasn't too far off from that when considering punitive damages, and Consun never made any good faith attempt to really resolve this case, and that is one reason why this case went so long. Quite frankly, it could have been settled had there been any reasonable attempt by Consun to do so. So prejudgment interest should have also been awarded. Thank you.
Thank you. And you have your full 5 minutes for rebuttal.
Thank you. Just briefly address two things. So at page 7 of appellant's brief, we do cite for the court this court's ruling in Evans v. Akron General Medical Center, 2018, Ohio 3031, which did confirm it is a 2-year statute of limitation for negligent retention and supervision. And I just want to touch on Judge Sutton's question of what happens if you should throw out either of these two that I've argued today. So it was a general verdict that was used in this case. And you can see from the record, defense, we actually had proposed individual verdicts and forms and interrogatories for each cause of action. Because if you don't, we have no way of knowing how much value the jury would have put on the negligent retention claim, the gender discrimination, or the sex harassment claim. So that is unfair, and we can't do it because they chose not to use the individual verdicts for each cause of action and the interrogatories. The general verdict is all we have, and it doesn't tell you what the jury was thinking, so it has to be vacated. Subject to any questions?
See none?
Thank you.
Thank you, counsel. And thank you both for your presentation today. The court will take the matter under advisement and issue a decision in due course. The clerk will mail a copy of that to you with release, and will also be released on the High Supreme Court's website as well.